We are seated here, and the purpose that has brought us for this discussion is a new emerging area that has been provoked or that has come into debate today into the legal circles because of innovations around technology. What is it that we are taking to court that we are disputing over? And I believe from what we have been engaging in since yesterday when I looked at the program, I believe we have continued to have a good appreciation of why this is a new niche area for people who say we are interested in technology practice and you're speaking AI.
How do we use strategic litigation to enforce the decisions of the regional courts? Because we have tried them, we have gotten good judgments, and we know the partner states have committed to adhere to the principles enshrined in the treaty, and they have signed several treaties.
When I come to the domestic court, I go for enforcement, and then I be relying on that very decision of the ESCJ to say here is a binding position of the law. The good news would be the more these decisions are adopted by our domestic courts.
It's a mentality in the judicial officers, that they're just not happy that anyone can have the privilege to file a reference directly without having to first file a case before the High Court, back home. And so that for me becomes an opportunity in this case where I have an issue, file it. If they're able to hear it, well, if they need interpretation, we seek interpretation from the ESCJ, and then have for the domestic court just have it endorsed. And so it makes enforcement a little bit more easier.
I would simply put that the lawyer's role is to ensure that he does due diligence. After the AI gives you whatever it's given you, go back, read it. Some lawyers are just simply lazy. They feel that the machine is more perfect than I am. So whatever the machine gives me, I'm going to take it as it is.
It is as a result of those and a few other cases that this bill was proposed so that they can also recognize gig workers as workers, and so they can have benefits of just even enabling them to unionize, allowing them to have benefits like health insurance. So I think it's one of the emerging responses that we are seeing from the region.
So as lawyers, we need to go back to the basics. Those principles you've been taught in law school should apply. ChatGPT as not all the other AI tools have not yet learned to have those when they're drafting those documents.
I think there is an opportunity for us as lawyers, whether it's us as law firms or lawyers as independent third parties or researchers, to try and help audit these algorithms for fairness.
Governments have seen a need and have called out to organizations that work on digital rights and have sort of embedded some aspects of AI and digital rights. For the case of Uganda, it is CIPESA that is working with the ministry to amplify these kinds of work, and this is with the help of Enable. What are we protecting in this space? Freedom of expression, non-discrimination, profiling as we said it, as well as posing these unique challenges to human rights that you packed previously in the end.